From supplementary list, item number 1.
Apologies, I could not be personally present today.
Yes, Mr. Pathak, what is the matter about?
The matter, my lord, relates to parity of pay and rank, my lord, in the clerical trade in Assam Rifles. But the issue was
This is
earlier
an appeal.
decided.
This is an appeal.
This is an appeal, my lord.
All right. Have you served the other side?
My lord, I have served my.
You're appealing?
Yes, Your Lordship.
And Dr. Mosika is leading you?
Yes, Your Lordship.
Dr. Mosika. Mr. Devnath is appealing. Very well. In view of the ground shown, what is the matter about? We'll proceed with the matter straight away. Tell us the matters.
My lord, the facts are like this, my lord, that this clerical trade in Assam Rifles, my lord, they were not given the benefits of certain recommendations of the Fifth Pay Commission. And earlier there was a round of litigation, my lord, in WP 61 of 2012, my lord. That matter was decided, and accordingly around 1,300 petitioners who were there, my lord, they were ultimately conferred the benefit in 2016 and 2019. So 2019, my lord, the persons who were left over in the same clerical trade, they approached for a similar benefit. Now the learned single judge basically has proceeded on the premise that we were fence sitters earlier, and since
No,
we
that's
did
neither
not.
here nor there. Neither here nor there. The employer has to abide by a previous result which becomes binding in respect of the same class of employees. And no distinction can be made because they did not join the petition or because they did not come to court. Let us say the ratio in the previous litigation is that all red-headed men will get 50 rupees. Then not only will the red-headed men who came to court get the allowance, hundreds of others who did not come to court will get the same allowance. The matter becomes binding, and it's as far as the employer is concerned, it's barred by issue estoppel, and the same benefit has to be given to everybody. There's no question of fence-sitters. Yes, Mr. Devnath. See, the problem with you is you will never do a matter, you will only seek adjournment and you will run away. That's the problem with you.
Your Lordship, in this case, whatsoever learned friend is saying, it is not the correct position, Your Lordship. What's happened, Your Lordship, in the single bench, we have executed here, Your Lordship. As per recruitment rule.
Let us see the judgment, and you provide no assistance to court.
My lord.
Let us see the judgment. If the judgment is on those lines, we will set it aside.
My lord, page 440, my lord, Annex 3.
Page 440, yes.
My lord. The finding, my lord, is in
Just a
para
second.
20.
Just a second.
My lord.
So the judgment has been implemented. That comes
This is-
paragraph 6.
My lord.
To the remaining 89 original petitioners who are also now covered by administrative order such. Now, who did these cover? What was the, can we see the order please? The original order?
My lord. That would be at page, my lord. Page 326, my lord.
326.
By Justice
Part,
Anima.
Mr. Patak. Where is the operative part?
Operative part, my lord, should be page 337, my lord. Para 12.
Page 3,
337.
337.
Para,
Para 12.
para 12. In the case of Dineshan KK
Yes,
Supra.
the union admitted on recommendation for the Assam Rifle person have been granted revised pay and internal lines of, but changes in the rank structure was not carried out like others have. Therefore, an apparent disparity in the service conditions of certain category of personnel however resulted. Also been admitted that there is no discriminatory academic qualification, nature of duties and responsibilities. On a totality of consideration, reasons taken by the intent to set aside discriminatory such and such, in the results with the direction to take up the matter again with the respondent number 1 to bring parity in respect of rank structure and pay of the Assam Rifles clerical cadre at par with other CPOs by introducing rank of assistant sub-inspector at the entry grade and scale of pay so and so, or any, with effect or any other deemed fit. In the letter, your clients claim to be similarly situated as the petitioners in this case.
My lord. They were also in the clerical trade, my lord.
And all the other circumstances are similar. There can't be any dissimilarity.
My lord.
Where is your assertion to such effect in your petition? When were you enrolled? When were you enrolled, Mr. Patak?
My lord, the various dates are given, my lord, at para page 125 onwards, my lord. Lordship will find the
Sorry.
entire list.
Sorry, you got to come prepared, sir, in this court. File your opposition to the Section 5 application. If you are not prepared, we can't help you. Evidence opposition to the Section 5 application be filed within 6 weeks from date, reply thereto if any, within a fortnight thereafter, the application will come up 8 weeks hence. Yes, next matter please.
From the
We would have
means,
finished the matter in 5 minutes.
from the means, item number 1.
Probably the page is not telling, my lord. Please, my apologies, my lord.
Yes.
It is. In this case also is an appeal which we filed an application for condonation delay.
Yes, who's appearing on the other side?
But I am appealing for this.
Yes. Yeah, what is the matter about,
Lordship,
what is the matter, what are the merits of the matter?
coal supply agreement.
Yes?
Coal supply agreement.
Yes.
The party, they approached us to give them coal for their cement plant. We, to certain quantum, under certain terms and conditions. They violated that. They did not lift the entire quantity as required. in 2 years. The first case is regarding 2008 to 11, and the other one is 11 onwards. What happened is, when they...
So there was a minimum guaranteed amount.
Yes, minimum guaranteed
They
amount.
failed to lift the minimum guaranteed amount.
Yes.
And you claimed.
Yes,
And they filed writ petitions and they've succeeded.
they succeeded.
Now, what is the ground? What is the basis for the order?
They- No, we filed an appeal against the first judgment.
You filed an
Appeal. And that appeal was disposed of with the direction to the parties to go for mediation as provided in the agreement. Mediation failed. And then the party, they again approached the Honorable Court.
Yes.
And now,
Ultimately, they succeeded.
Yes.
What is the ground for succeeding? If there is a minimum guaranteed amount,
yes,
what is the ground on which the trial court has allowed the writ petition, saying that they were not liable to do that? Because your demand must have been quashed.
the penalty clause was there, and what has happened is when they refused to lift the entire quantity,
You are appealing for the other side, Dr. Saraf?
But I am appealing, my lord.
Yes.
My lord, if you also permit me, my lord, with the consent of the other side, my lord. My lord, the clause for the imposition of the amount, if your lordship looks into clause 4.5, my lord.
Your Worship, may I submit, we filed 2 paper books to make it more convenient for this Honorable Court.
Come, let us see the order. Let us see the basis for the order.
What is it? Page 305 to 338 of the paper book.
In the paper book, your Worship will find it at page 305.
5 to 338.
বেশি পয়সার বাগানে রেকমেন্ড দিছে নাকি?
That is arbitrary.
Order.
Where is the clause?
115A, my lord.
Sorry?
115A, 115A, my lord.
115A.
Page number 115. Rise to from time to time never operate. Clause 15. Clause 15. Transmission. And transmission process 125A basically.
ACQ is assured whole quantity.
Annual contracted quantity.
Annual contracted quantity.
Note the what detail.
Should we prepare this?
Dr. Saraf, what is the penalty?
My lord, I just my lord, the prices of the coal were increased by 60% in a year. I'm not on that, my lord. 4.5 says, my lord, about the compensation. Now,
Yes.
the appellants are saying that under use of the compensation, they can impose the penalty. Now, we took the statement.
Sorry, can't follow you. Your voice is not very clear. Yes.
Ballot by taking the resort to close for 4.5, the appellants are saying that they are also entitled to impose penalty. Now, as your lordship is aware, penalty cannot be imposed without a statutory provision. Penalty is not a matter of the agreement.
No, where is penalty?
Well, they have stated that we can impose penalty.
Where is the demand?
Compensation.
Well, demand, your lordship fine.
Page 1.
By
150?
Demand is at page 145 to 146A. 140.
Demand is at page 145.
145.
Yes, 145 and 144 also.
145.
Any one we can see.
Compensation.
What is FSA?
Fuel supply agreement. Fuel supply.
Fuel supply agreement.
termination clause is at page 125A, a termination clause.
Well, if you lost it, let's take the trouble of looking at the affidavit of opposition which was filed by the appellants before the writ court,
Yes.
It starts at page 252. And I will take you to only one paragraph, at page 289. Para 18, my lord. Had you also got it, my lord? The last 3 lines, my lord.
No, you have to read that last 3 lines in the context of what goes over here.
Well, absolutely.
What they say is, what they ask for is compensation. Compensation and penalty are not the same.
Well, I am on the same point, my lord. There is no dispute that the said coal was sold away to some other persons. It was specifically taken.
Therefore, that has to be gone into. Without going into that, how will you go? That's a matter of arithmetic and calculations.
Well,
Was it sold? Was it sold at the same rate?
No.
Well, I just submit, my lord, that the stand which was taken before the court, my lord, that the coal was sold and there was no loss, and they have not come up with.
Where is that? Where is that assertion that the coal was sold and there was no loss? Then where is that? Where is that admission in the pleadings?
Well, I just submit, just.
At least we did not find that in reference in the judgment.
Well, you also may see the first case when the matter was reached before the single judge, my lord. You also may see, my lord, when the matter was first taken to the single bench, my lord. Earlier, my lord, you also may see page 223.
223.
My lord.
Yes.
Para number 15, my lord.
All right, but this is not a.
This was not challenged before by them in the writ appeal also, that there was a loss. My lord, it was admitted loss. You see, most important question involved in this case, which is
No. This cannot be accepted at the end. Where is the figure that it was sold for this amount?
Nothing.
My lord, that they must come up. They are not said.
That's neither here nor there. You have to go to a suit. You have to go to a suit. This is not a matter where the writ court can calculate.
My lord, you let me just kindly see, my lord. When the
No, sir. This is not a case of penalty. This is a case of clear compensation. And if there is any penalty element that has to go to adjudication, you have to find out, you have to sift the penalty element from the compensation. They'll be entitled to compensation but no penalty. And that exercise has not been done in the writ petition.
My lord, it appears that I've not been able to persuade your lordship, my lord, to my lord.
No, sir. This is no persuasion. We are talking of 54 lakh and 74 lakh revenues deprived of 126 without any calculation. This is the calculation.
My lordship may kindly, my lord, if your lordship permit me, my lord, if your lordship so permits, that if 5 minutes your lordship may give me, I may just make submissions.
Carry on.
Or your lordship, my lord, because the matter was for the admission, your lordship may admit and fix up for the hearing so that I can make the detailed submission before lordship, my lord. If your lordship so permits, my lord.
In view of the good ground shown, the delay of
72 days.
72 days.
About 72 days in preparing the appeal is condoned and the appeal is taken on board. Paragraph. The only issue in the appeal is whether the 2 demand notices that were challenged by the petitioner respondent in proceedings under Article 226 of the Constitution of India amounted to a claim of penalty and not one of compensation or damages. Full stop. Prima facie, the judgment and order impugned dated March 1, 2023. Sorry,
2020.
dated, October 26, 2023, 2022. What did I say? Prima facie?
Well, if you lost it without expressing the
Then
prima
just
facie-
cut that out.
Well, you
The
lost
judgment
it-
and order impugned dated October 26, 2022 set aside the demand notices for sums in excess of rupees 54 lakh and 74 lakh only on the ground that the claims were in the nature of a penalty, full stop, paragraph. There does not appear to have been any exercise undertaken, in course of adjudication of the writ petition, as to whether the entirety of the two demands could be said to be claims in penalty or parts thereof could have been claims on account of damages suffered for the writ petitioner failing to lift the annual contracted quantity, full stop. It is submitted on paragraph. It is submitted on behalf of the respondent herein that the entirety of the shortfall was subsequently sold by the appellant herein, and as such, there could have been no claim on such account otherwise than by way of penalty, full stop. Paragraph, however, an adjudication on such aspect requires evidence to be received as to the rate at which the shortfall was sold, the time for which the shortfall had to be preserved for the respondent herein to lift the same and like issues, full stop. Paragraph, since the respondent seeks time, let the matter appear 3 weeks hence.
I'm obliged, my lord. The second matter is the same, my lord.
Yes, same.
Years 11, 12.
Only the years are different, 11, 12, the second petition.
We have not referred to any year in any. But in the first petition, there are two demands, 54 and 74. In the second petition, there's some other demand, not the same.
My lord. My lord.
Very well.
Would you prepare a small note for your
You don't
lordship?
need notes.
No.
Nandinile.
3 weeks.
My lord, this is the matter pertaining to illegal extraction of coal, transportation of coal, and then exporting those illegal extracted coal, my lord, from Garo Hills, my lord.
Yes. Who is appearing for respondent number 14?
My lord, I am appealing, my lord. I am appealing.
Yes.
On earlier occasions, my lord,
Just
the
a
learned
second.
counsel, the earlier council is having some problems.
That's all right. Send it to jail and look at what your counsel is doing.
No, my
Haven't you seen the previous order?
No, I have seen
It
it.
says you're playing fast and loose.
No, I have seen.
And you still have the courage to say,
No, my lord, I appeal, my lord. I am appealing, my lord, before your lordship.
tell us, how did you acquire the 52,000 metric ton of coal, which is referred to in that letter?
Yes, my lord, I have the invoices with me, my lord, right now. I can produce along with, my lord, the challans and e-way bills, my lord, with me.
Since the 14th respondent claims that challans, invoices and e-way bills are available in respect of the 52,000 MT of coal that it sought to export to Bangladesh in April 2022, let the matter stand over for a week, full stop. The respondent number 14, is it a person or is it a company or something like
It's a
that?
company.
It's a
my lord.
company, company, my lord.
It's a company.
Company, my lord.
The principal person in control of the respondent number 14 company will affirm an affidavit appending copies of the relevant invoices, challans and e-way bills pertaining to the said 52,000 metric ton of coal, full stop. Paragraph, it appears from the previous order of March 22, 2023 that the respondent number 14 was also in possession of approximately another 1.25,000 metric ton of coal, full stop. Relevant documents pertaining to such quantum should also be incorporated in the affidavit, if possible, full stop. Paragraph, at any rate, no delay in the filing of the affidavit will be accepted, full stop. Even if the documents pertaining to the balance 1,25,000 MT of coal may not be available, since it is the clear and categorical submission on behalf of the respondent number 14 in court today that the invoices, challans and e-way bills pertaining to the 52,000 metric ton of coal are available, such documents must find place in the affidavit, full stop. The relevant affidavit should be filed by April 4. The matter will appear on April 6.
My lord, may I pray a little accommodation?
No, not at all. Thank you.
My lord, I have.
That's all right. Thank you. Call on the next matter, please.
Item number 2.
My lord, only thing, my lord, what I submit to your lordship, my lord, e-way bills are very voluminous, my lord. It's a 3-box, my lord. I have brought the boxes, my lord. Now it will be very difficult to either I have to file it like this. So there's 3 boxes of big boxes.
If that's too voluminous, you bring them over here, refer to it being voluminous, do the other ones which are within control, do the e-way challans and the e-way bills and the invoices, do those, and the other ones which are there, you say, write a thing in your affidavit that it is with your advocate on record, we'll give inspection to the parties for it.
Yes,
to be
but,
yes. Those are things that we...
The main important thing is, my lord, is the purchase bill.
Let us see what they bring. Let us not presume. If they say they have, we have to presume that they have.
These are the challans, and e-way bills, where the trucks goes, they have the stamps, And these are the UA bills are there. The voluminous, my lord, I can produce before the court and they can inspect, my lord.
We will look at those primarily.
My lord.
Your invoices.
UA bills, my lord. Okay, fine.
No. Invoices are not UA bills.
No, invoices are different, my lord. And invoices have been,
Yes.
UA bills are, and where the tracks has been going on, my lord, what are the...
We may not be looking at.
My lord.
But if it's too voluminous, say that, we'll accept that. Don't worry.
Much obliged, my lord.
Yes.
May I please, Your Lordship?
What is that? Who are you?
Lordship, I'm Nasim Akram Majar, Advocate, Guwahati High Court, appearing for the petitioner, the PIL number 1 of 2023.
No, there was someone who was appearing for the petitioner in court. Yes. We passed an order on PL. This is PL number 1. This is a new matter, this is different matter.
Item number 2.
You have not called it on yet? Okay. Yes, what is this matter about?
Lordship, this is a matter regarding the petitioner challenged the illegality and validity of the illegal transportation or export of coal by respondent number 11.
Yes.
That are being exported to Bangladesh as coal originating from outside Meghalaya. Whereas the said coal is actually mixed, mined from the Garo Hills in connivance with the authorities. Lordship, we have also found some discrepancy in UA bill and the movement of the...
Is the respondent number 11 the same here as the respondent number 14 in that case?
No.
You are appealing for respondent number 11. Yes.
So, may I continue, Lordship?
Yes, please.
Lordship, so there are some discrepancy we found in the UA bill and the movements of the trucks which contain the coals. So in that regard, to substantiate our allegations, Lordship, we have filed an RTI dated on 14th March 2023 regarding this, informations of this UA bill and the movements of the trucks. So Lordship, at the same time, the petitioner filed an affidavit in opposition, and we are preparing a rejoinder to the affidavit in opposition. So Lordship may kindly accord us some time so that we can have that information.
Are you appealing for the petitioner?
Yes,
How have
Lordship.
you filed any affidavit in opposition?
Lordship, we are preparing to file a rejoinder to the affidavit in opposition, Lordship.
For which we had given you time last time on 13th of March.
Lordship,
Petitioner seeks time, very well, we're giving you time. The petitioner seeks time on the ground that some of the documents relied upon by the respondent number 11 may be suspect, and RTI queries have been raised by the petitioner to which no reply has yet been received. Paragraph. The time to file the petitioner's rejoinder to the affidavit filed by the respondent number 11 is extended by 3 weeks from date. The matter will appear 4 weeks hence.
Lordship, I hesitate to jump in. One small submission, my lord.
Yes.
Yesterday, we had filed a miscase for respondent number 11. That is on record, my lord.
What is the miscase about?
Lordship, what has happened suddenly is that we have been visited by a major inconvenience by the state respondents. If Lordship kindly has the miscase, my lord.
Yes.
Miscase 1, my lord.
Yes.
My lord, the miscase is before you. If Lordship kindly looks at page 64, my lord.
64. Yes.
64, my lord, is dated 8th December 2022.
Yes.
This was a permission that was accorded to us, my lord, for exporting coal, to obtain coal from outside the state and to export it further to Bangladesh, my lord.
Yes.
This was last year, December.
Why does it not bear the signature of anybody? This appears to be a photocopy, but why does it not bear the signature of anybody?
Lordship, page 65, my lord. It continues, my lord.
All right, yes.
So this was accorded, my lord, in December last year. Pursuant to that, my lord, page 67 may kindly be looked at, my lord.
Yes.
Page 67, my lord, this is another order following the first order. In pursuance of letter memo number so-and-so, dated so-and-so.
Very good, yes.
Received from the Director of Mineral Resources, etc. Permission is hereby granted to Shri so-and-so of so-and-so to export the coal originated from outside the state of Meghalaya through Dalu Land Customs Station at West Garo Hills District and Gasupara Customs Station in Bangladesh with effect from 12th December 2022 to 12th January 2023. Now, my lord, this period came and went. We applied for an extension also. That is at page 72, my lord. Page 72, my lord, we applied for an extension. Extension, my lord, was duly granted, page 73, my lord. If lordship kindly looks at page 73, the last portion of the first paragraph itself, my lord, will suffice. 1st February 2023 to 2nd March 2023. Extension was granted, my lord. 1st February, my lord, coincidentally, is the same date that this particular PIL was listed before this Honorable Court. 1st February, and this order, my lord, this extension is dated 1st February. Surprisingly, my lord, 6 days later, a withdrawal is issued, that is at page 135.
Page
135, my lord. My lord, pending verification of some documents, the permission granted to Shri so-and-so of
Very good. So what do we do?
My lord, what has happened because of this withdrawal?
No. The application is completely misconceived and beyond the scope of the writ petition. Full stop. It is elementary that any application or prayer in course of any proceedings has to be in aid of the proceedings and not otherwise. Full stop. Paragraph. The charge in the petition filed in public interest is that the respondent number 11, in connivance with the state authorities, has purported to export coal illegally mined in this state to Bangladesh by falsely claiming such coal to have been obtained from elsewhere. Full stop. Paragraph. The grievance in the miscellaneous application filed by the respondent number 11 is that though permission had originally been granted and the time for exporting the goods to Bangladesh had also been extended, by a recent notice issued sometime in February 2023, the permission has been withdrawn on the pretext that some documents have to be looked into by the state. Full stop. Prima facie, it appears that the state may have become wiser upon this PIL being filed. Full stop. Paragraph. In any event, the prayer made in the miscellaneous application not only has no nexus with the petition, but is contrary to the object with which the petition was filed. Full stop. Accordingly, this case number 1 of 2023, filed in PIL number 1 of 2023, is dismissed with costs assessed at rupees 10,000 to be paid to the Meghalaya State Legal Services Authority within a fortnight from date. Full stop.
Item number 3.
May we please, Your Lordship? Your Lordship, this is a case where a confessional statement is being solely based, Your Lordship, and that has never been exhibited.
And
the confessional statement which has never been exhibited, it never been exhibited, the Lordship could belong to this entire conviction on the confessional statement.
Is that the case, Mr. Khan?
Yes.
Confessional statement not exhibited and conviction is based only on the confessional statement.
There is some grey area, Lordship. We'll just come to reply.
No, but if that is the case, then there's no question wasting time. Then we'll set it aside and then send it back for retrial.
Lordship, I have a reply to that. CRPC, there's a provision in CRPC where certain documents which is part of the charge sheet can be relied on by the judge while adjudicating.
But not a confessional statement.
Not confession.
But this was part of the charge sheet.
May have been a part of the charge sheet. Was it supplied to them?
Lordship,
Under 207?
Lordship, yes.
But you did not exhibit it.
Not
appears so, Lordship.
If you did not exhibit it, then the trial court could not have relied upon it.
But Lordship,
there are certain things for which clarification and things like that, whatever is filed with the charge sheet, 161 to the extent of corroboration, to the extent of contradiction, the court can look into that. But even if they are not exhibited.
Lordship, the person, yes, but the person who recorded this is 164.
Person who recorded the 164 was examined?
Lordship, yes.
No.
Then,
so it is admitted by Learned Court below at page 104, if your Lordship is pleased to turn, of the judgment. Paragraph 40, your Lordship.
how is the existence of the document as 164 proved? If the person who recorded it is not examined?
Let us come.
No, Lordship, the person did not.
Then consider it. If you want to pursue it, we'll let you. Show us the provision in CRPC.
Lordship, yes. $394.
Section
394, Lordship.
397 is
No, not 394, I'm sorry.
397 plenary authority.
Lordship, sorry. Lordship, can you just give me a minute?
Court.
Lordship, can you just give me a minute? I'll just come to it in the meantime, miss. Just a minute, Lordship. I'll just get back to the exact
Just
provision.
tell us which provision. We don't want to hear anything else. If the document has not been exhibited, if the person who recorded the confession has not been examined, then the veracity of the document has not been established. It could be a bona fide mistake. We all make mistakes. Come back tomorrow and tell us.
Tomorrow, Lordship, I'll just come back to the issue. Otherwise, it's a fit case for him, Lordship.
Fit case for retrial.
Absolutely.
Consider it after all. You have nothing to, no axe to grind
Absolutely,
against.
absolutely correct, Lordship.
You have to be as fair to the convict as you have to the
Absolutely,
victim.
absolutely, Lordship.
Very good.
Tomorrow.
Tomorrow in the supplementary list.
Much.
Let the matter stand over for a day. For the day.
Item number 4,